Okay, so today we're going to be getting into Chapter 5, and I want to go into a couple of concepts that are listed here. We're going to be talking about what we mean by due process. We're going to be looking at the exclusionary rule, the fruit of the poisonous tree doctrine, and then we'll go into some of the searches, such as a search incident to arrest, the plain view doctrine, emergency searches, and we'll talk a little bit about the Miranda versus Arizona case. The first thing that I want to mention is just this term due process that we hear. Basically, what that means is fairness. Due process essentially translates to the term fairness. When we're talking about fairness, what we're really looking at is, are we treating the suspect essentially in a fair manner, in a manner that is consistent with the values, with the principles, and with the laws under our Constitution and our federal and state governments. So if you kind of keep that term fairness in mind when it comes to due process, that will really help you as we go from this point forward when we start talking about court processes and things of that nature. So in light of this term fairness, let's start looking at the exclusionary rule. Now, the exclusionary rule simply means this, that any evidence obtained in violation of the Fourth Amendment protection against unreasonable searches and seizures cannot be used in court. We really didn't have the exclusionary rule until the 1914 case of Weeks versus United States, and this was a federal case. This only dealt with federal officers. Up until 1914, federal officers could go in and illegally search, illegally seize evidence, and there was no penalty to it. And so the court here created the exclusionary rule. From this time forward, only applying again to federal officers, did the exclusionary rule say that we can't use this evidence in court. It wasn't until the case of Mapp versus Ohio, which came about in about the 1960s, that we started applying the exclusionary rule to the states. And so what it basically comes down to is this. Anytime police officers violate somebody's rights when it comes to search and seizure, we cannot use that evidence in court at a trial. Now understand, we can use it during other proceedings, just not at trial. It can be used at sentencing hearings. It can be used at probable cause determinations. We can use it for civil proceedings and anything else. It just cannot be used at trial. Closely related with the exclusionary rule is what we call the fruit of the poisonous tree doctrine. And I want you to picture this. The easiest thing to do is to picture a tree. And a tree that has branches, and the branches have fruit on them. And this is why the court actually called it the fruit of the poisonous tree doctrine. If the tree is bad, then it's going to produce bad fruit. And what the court said here is that if the initial evidence that is seized is illegally seized, then anything we get from that is also out as well. In other words, the exclusionary rule applies to it. Let me give you an example. Let's say that I'm a police officer, I go to your house and I kick in your front door. And I go to search your house, and on the table of your house I find a note that says, "I buried the body under the tree out back." So me being the resourceful investigator I am, I go get my handy dandy shovel and I go out to the backyard and I dig up underneath the tree, and sure enough, there I found where you killed somebody and you buried the body. Let's go back and look at this scenario. The evidence that's initially seized, the note, is bad. Why? I didn't have a warrant to go in your house. I didn't have consent to go in. So therefore, at trial, the note would be out. But what about the body? Well, the court says that because of the note, I found the body. Had it not been for the note, I wouldn't have the body. So therefore, the body is fruit of a poison tree and is also excluded. Now, there are some exceptions to the exclusionary rule, and basically these exceptions focus on one main point. Did the police make an error? And if they did, was it accidental? Was it unintentional? And if it was, then the evidence may be allowed in still. So your book goes over several exceptions to it, and I'm not going to talk about those in the video, but you can read through those yourself. Let's talk about a couple of the searches that are listed in here. We're talking about the Fourth Amendment. Let's look at the searches. Search incident to an arrest. A search incident to an arrest is a situation where I have the right to search somebody because I arrest them. Now, let me explain an arrest here. If I write somebody a citation, that does not qualify for me to search them under a search incident to arrest. If, however, I am taking them to jail, then I can. A search incident to an arrest is basically for two purposes. Number one, to ensure that the suspect doesn't destroy any evidence. And number two, to ensure that the suspect doesn't have any weapons or contraband on their persons. This is what we call a lungible search. It gives me the right to search in an area that is within the suspect's immediate reach or lunge area. If we're in a house, for example, I could search the suspect's immediate surroundings. I probably couldn't go into another room and search there. That would certainly be outside the lungible area. But I could search the area that's immediately around the suspect. In any situation, however, if I see something in plain view, it's seizable. So let's say, and I'll give you an example of a call that I had. We had a call one day to go into a guy's house. We get there, he needed us for some reason. We go into the house. As we're in his house, we see a marijuana cigarette burning on an ashtray. Well, the law says that's in plain view. I have a right to be there. What I see is immediately recognizable as contraband. I can seize it. And as long as those two criteria apply, anything that we see can be seizable. So let's say I'm a police officer and I'm walking through the parking lot of a school and I look into a vehicle and there inside the vehicle is a bag of cocaine sitting on the seat. That's in plain view. I can wait till the owner comes there and sees it. I can do several other options. But when it's out in the open and I have a right to be there and I recognize that the item is immediately subject to seizure, that's in plain view. Just want to mention emergency searches. Emergency searches are another instance where we don't have to have a warrant. Case we had one night. Guy's passed out in the middle of a highway. We get there, we pull up there to him, we try to wake him up, he won't wake up. The law says I have a right at that time to do an emergency search. Now, what am I looking for? Am I looking for evidence? No. I'm looking for identification. I'm looking for something to tell me who this individual is or if he has a medical history. So in those cases, I can do an emergency search of a person. We can also do emergency searches of vehicles as well. Emergency searches of vehicles are typically done without a warrant because requiring us to get a warrant would simply take too much time and it's not feasible. Let's say I pull somebody over, and when I pull them over, maybe I suspect and have probable cause that they have drugs in the car. Is it really feasible for me to ask the driver to stay there while I go to the magistrate's office and get a warrant and come back? Absolutely not. The chances of this guy driving off, pretty high. So what we do is we are allowed to do a vehicle search based upon probable cause and without a warrant. The final thing that I want to mention real quick is what we call Miranda. Now, Miranda gets into the concept of interrogations and interviews, and I want to differentiate between these two. Keep in mind, an interview is really nothing more than asking questions to get information, to find out what happened. If I go out to a scene where there's a fight and I start interviewing people, I'm really doing nothing more than trying to put together what is it that happened here. An interrogation is a little bit different. An interrogation is when we've actually located in on somebody as being a suspect, and I'm wanting to ask them whether or not they did it. I'm basically looking for incriminating statements here. Miranda doesn't kick in until we have an interrogation that's in place. And for Miranda to apply, there are two things that have to happen. Number one, the person has to be in custody. Now, how do we define custody? Custody is simply defined as when a person has a reasonable belief that they are not allowed to leave. Now, I want to kind of talk about this for a second. There are times when we can do what's called an investigative detention, and it's not considered custody. Let's go back to my fight scene for a minute. I can legally hold the individuals there as I do my investigation to find out what happened. I can hold them there for a brief period of time while I try to figure this out. And they are in a temporary detention. They're not in custody for Miranda's sake. Where Miranda kicks in is when I have made the determination that this individual that I'm holding is now a suspect and I'm questioning him about his involvement. That's when Miranda kicks in. So two things. Person has to be in custody, and the person has to be interrogated. When we get to the interrogation portion, if I don't ask any questions, Miranda doesn't apply. There were several times in my law enforcement career, well, I'll arrest somebody and I don't ask them questions, put them in the back of my patrol car, and they will start telling me what happened. I don't have to read the Miranda in that case, even if they admit to it. The reason is because I'm not questioning them. That is a free and voluntary statement that they're giving. The other thing about Miranda is I can ask biographical questions. I can ask questions about anything except the criminal offense, and Miranda doesn't apply. So if I've got the same guy in my back seat of my car and we're driving to the jail and I say, "Hey, John, how's the weather today? What do you think about the Atlanta Braves?" And he says, "Neil, I think the Braves are great. By the way, I did beat my wife today." That statement is admissible even if I did not read him his Miranda rights. One other thing about Miranda that I want to mention, most of us know what the rights are. We have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one, one will be appointed for you. But what most people don't know is that there are actually two sets of rights in the state of North Carolina. One for adults, one for juveniles. The ones that I just recited are the rights for the adults. Juvenile rights contain one extra right. And when I say juvenile, a person who is arrested who is under the age of 18, so they're 17 and below, have the right to have a parent or guardian present during any questioning. In North Carolina, if they're less than 14 years old, you must have a parent or guardian present during questioning. With other rights, the defendant has a right to waive their Miranda rights. A 14-year-old or less cannot waive their right to have a parent or guardian present. But if you're 18, all we do is we have the person sign a waiver that says, "Yes, I understand my rights as they've been read, and I want to answer questions anyway." That's a valid waiver. If, however, the person at any point in time during the questioning wants to reassert their rights, then all questioning has to stop, and they have the right to do that. So those are a couple things we're going to be looking at in this chapter. If you have any questions about any of these concepts, post it up in the questions and answers forum, and we'll be glad to respond to it as a class. Or if you have any other questions, you can feel free to call me or email me.